Following on this episode of Law Weekly, we talk about the quality of legal education and how it affects the standard of legal practice. We have the views of Mr. Atiku Jafar, the National President, Law Students Association of Nigeria, LAWSUN. We also have some of the highlights from the 13th Annual Business Law Conference of the Nigerian Bar Association section on business law, plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I am Shola Shieli. The public trials of judges and lawyers accused of corruption and the general poor perception of the judiciary is not unconnected with the falling standards of legal education in the country. This is the view of my guest, Mr. Atiku Jafar, the National President, Law Students Association of Nigeria, the umbrella body of all undergraduate law students in the country. Here's our conversation. So let's start with what necessitated the setting up of LAWSUN. What does it seek to achieve?
Oh, well, the Law Student Association of Nigeria has a very fine historical antecedent. It traces back to the late 80s, 90s, the golden days of student struggle. We used to have the National Association of Law Students. For some political reasons, it went into extinction. And lately, a lot has been going on, incredible work at university level, the law student societies and law student bodies that we have. And we hear about recent outcries by senior lawyers, president of the Nigerian Bar Association and senior members of the inner bar, lamenting the quality of legal education in Nigeria. We hear about rampant violation of student rights, disregard for the rule of law within the four walls of our universities in Nigeria. So we recognize the need for law students to kickstart a process that will lead towards national cohesion, to create an umbrella body for law students that protects the interests of law students, number one, and equips them with the wherewithal to tackle some of these issues that border strictly on them. If we do not speak for ourselves, nobody will speak for us. And that is what informed the decision of virtually all the faculties of law in Nigeria to convene in 2016 and inaugurate a student body geared towards national cohesion, national unity of law students, and coordinated law students at the national level.
It's interesting that you talk about legal education, but has LAWSUN taken a stand on the quality of legal education in the country, and what is the verdict?
Oh, of course, we have several times. One of the key things that informed virtually all of our policies is to pursue a comprehensive system that will equip law students with the requisite skills to build a robust legal profession. Because we know that come what may, we are the people that are going to man the affairs of the legal profession, be it the bar, the bench, or whatever capacity lawyers are being bred to maybe stand. So we are concerned about the need for a revolution or a reform in the way law is being taught in our law school and in our law faculties. You hear senior lawyers lamenting that the system is porous, the standard in legal practice is falling, and the lawyers that they employ in their firms have to go through some series of fresh training, as if they have not had any encounter with legal education or legal training at all. So this calls for a serious concern.
What do you think is wrong, though?
Now, what is responsible for it is that attention has not been deployed, resources have not been deployed into, first of all, identifying what is being done at our law faculties and how do we identify the problems, maybe with a view to tackle them. First of all, we identify some critical areas that bedevil legal education. Our curriculum, number one. What is being taught is largely archaic and out of fashion. There are virtually conservative aspects of the law that are not relevant today. The world is evolving. We hear about corporate investment, capitalism, corporate practice, openings for lawyers, very lucrative areas that are not being taught in law school. So there is a need to maybe channel the resources that are being deployed towards law teaching to equipping our lecturers, number one, with those practical skills to impart on law students, and number two, to drive in reforms and creating a platform for law students to access their career potentials. That has not been done in the law school. The concern or the attention has been largely on substantive aspects of law teaching, to the extent that there is a gap or a disconnect between what is being taught in law faculties and what obtains in the Nigerian law school. And it seems that in the Nigerian Law School and our law faculties, law students are being trained not to become fine lawyers, critical lawyers, but they're being trained to graduate from law faculties and to graduate from law school. So we have to interrogate that very, very critically.
Where do you put the responsibility? Who has the responsibility for driving some of these reforms that you've talked about?
Now, we have regulatory bodies. We have the Council of Legal Education, and we have the Nigerian Universities Commission. And quite sure we have lamented that the fusion of powers, regulatory powers, between the NUC and the Council of Legal Education breeds uncertainties. I mean, there has to be a body that is saddled with the responsibility of regulating legal education at all levels, be it at the university level, at the law school, or elsewhere. So we have cried out that, look, Council of Legal Education, come to intervention, come to aid, look closely into what is being done in our law faculties. Because as much as we are within the four walls of universities, law teaching is in such a way that students are being equipped to pass through a transitional period, maybe graduating from law faculties and going to law school. The legal education as it is fashioned today is a product of the recommendations of the Unsworth Committee in 1962. Nothing much has been done, despite the evolution of very, very recent areas of legal practice. The curriculum is largely dated. What has been taught previously in the 80s, 60s, and in the late centuries, previous centuries, is still what is being imparted on law students today. So it calls for a critical reform. Perhaps the wordings of Lord Denning comes to aid, that if we do not do what has not been done before, we are going nowhere. The world will always move on, and the legal profession will stay behind, and it will be bad for both.
Talking about the curriculum, what are some of the new courses that you think should be introduced?
First of all, there needs to be a critique of what is relevant and what is not. There are quite interesting areas of law that have been in existence and are still relevant. Talk about the foundational courses of constitutional law, legal system, and whatnot. But then we need to look at the curriculum, the evolution in terms of these very courses. We need to look at what is still tenable in practice within the purview of those courses and what is not. And we need to look at very, very lucrative openings in legal practice, such as capital markets, such as corporate governance, such as securities law, space law, intellectual property law. I mean, this is the new crude oil of the legal profession, and law students virtually get to hear about them after they must have passed through the undergraduate process. Well, some of them are being maybe given out at the undergraduate level at a very insignificant level. So we need to drive a lot of focus towards identifying, first of all, what are the key areas. And that is a major challenge. We are tasking major stakeholders in the legal profession. The NBA should be interested in what is being taught in the law school.
As an association, what do you do for yourselves?
Well, what we do since assumption of office, we have virtually as a baby association that was created in 2016. We are focused on integrating the various law faculties we have nationwide. We have almost 55 of them accredited by the Council of Legal Education, integrating them, uniting them, and pursuing programs and projects geared towards sensitization, number one, recognition, and creating awareness that, look, Lausanne is here, and Lausanne is saddled with a lot of responsibilities. And what we are seeking to do is to unite law students, broaden the knowledge of practical skills. We have partnered with several bodies in that regard to maybe equip law students, since we have noticed that there is a rupture in terms of capacity and quality of legal education. So before we achieve them very formally and institutionally, we are doing what we can at our own levels.
Finally, how would you say Lawson is contributing to national development?
Oh yes, law students are critical stakeholders in policy formulation process. And by the creation of Lawson, we coordinate student activities nationwide. I'm going to cite example through the operational mechanism of Lawson. We operate through, nationally, we have the executive arm, the executive council, we have the Senate, and we have specialized directorates. We have the Directorate of Student Rights, we have the Directorate of Research and Training, and we have the Directorate of Legal Aid. What the Directorate of Student Rights does is that they identify cases of human rights violation and human rights abuses on university campuses, and they fight them, they defend them, and they stand for the right of students. And this human rights struggle is very, very significant, because we believe that we law students have what it takes to defend our fellow students and sensitize them against maybe standing for their right and securing the welfare of their rights. Secondly, we have the Directorate of Research and Training, which I served under before becoming president. I am very, very proud of the work we do at that directorate. We identify the lacunae in legal education, and we pursue policies and projects geared towards maybe rescuing them. And we organize trainings, workshops, moot court competitions between law students, all geared towards doing that. Another fantastic thing we've done under our administration last year is that, having recognized the power tussle between the executive and legislative arms of government, we convened the Lausanne National Legislative Summit in Abuja at Bayes University, where we interrogated the extent of legislative powers over budgeting, and recommendations of which were sent down to critical stakeholders, law students, to look at these, what the speakers have to say, and listen attentively and equip themselves with the resources. So this is very fascinating. It is geared towards national development and national cohesion, national integration.